Good morning, this is your Kelso Report for Tuesday, October 2nd. I'm your host, Clark Kelso. It was a light day for the courts yesterday, only 2 cases. We begin today with a decision involving how to count indecent exposures. And our second case involves the difference between waiver and tolling in the context of the statute of limitations. But first, indecent exposure. And we begin today with the much vexed question: how do the courts count the number of times a defendant has indecently exposed himself to a group of successive witnesses? Well, the facts in People v. Smith were that the defendant exposed himself while standing outside a residential window. The occupants of the residence observed defendant exposing himself and quite sensibly closed the curtain to their windows. But curiosity apparently got the better of them, because very soon after that they reopened the curtain, and lo and behold, the defendant was still there exposing himself. But by this time an additional witness had come into the room to view the scene. The prosecutor, sensing an opportunity because the curtain had been closed but then reopened on the defendant's show with an additional witness in the audience, charged the defendant with 2 separate counts of indecent exposure. Well, the 2nd District Court of Appeal was having none of this and reversed the double counting, explaining that there was actually only a single exposure which could be charged. The fact that the audience decided to take a second look did not mean you could charge the defendant twice. And California's indecent exposure statute does not refer at all to the number of witnesses. So the fact that an additional witness showed up for the second viewing did not change the result. The defendant was engaged in a single act of indecent exposure, so only a single count could be charged. Good information to know. Next, tolling. Our second case today involves the proper interpretation of the word waiver in section 360.5 of the Code of Civil Procedure. Now that section has a requirement that an agreement to waive the statute of limitations be renewed every 4 years, and if not renewed, the waiver automatically expires. The statute was designed to prevent an agreement that waived a limitations period from becoming perpetual in its impact. The statutory issue arose in Don Johnson Productions v. Reicher Entertainment, where actor Don Johnson's production company was trying to recover a portion of the gross receipts from the continuing syndication of the Nash Bridges television series. A dispute arose between the parties in 1998 over contract payments, and as the limitations period for a breach of contract action approached in 2002, the parties entered into an agreement to toll the further running of the limitations period until either party terminated the tolling agreement on 30 days' notice. Well, the parties actually did not settle their dispute, and Don Johnson Productions finally filed suit in 2009. The defendants argued that the tolling agreement was subject to the 4-year renewal requirement in section 360.5. The 2nd District, by a majority 2-1, held that the statute, which originally was enacted in 1951, applied only to waivers of a limitation period. It's the language from the statute, waiver. And that an agreement to toll the running of the limitation period is technically not a waiver. The difference being that an agreement to toll simply stops the running of the limitations clock, while a waiver dispenses with the limitations period entirely. Since the statute refers only to waivers and not tolling, the majority of the 2nd District panel held the statute did not apply to the agreement between the parties, and the filing of the action in 2009 was therefore still timely. The The dissenting judge in the case noted that the tolling agreement between the parties had exactly the same effect as a complete waiver of the limitations period, and that the majority's holding meant the tolling agreement was effective essentially in perpetuity, since it did not require a renewal every 4 years pursuant to the statute. Avoiding a perpetual waiver of a limitations period was the purpose behind the statute, and the dissenting judge argued that the majority's holding seemed to be contrary to that purpose. Now, it does seem to me that dissent has the better argument in this case. The majority's holding requires it to give an ultra-technical interpretation to the word waiver that lets parties avoid the key purpose of the statute simply by changing the word from waiver to tolling, while still accomplishing exactly the same thing. So I would not be surprised to see the California Supreme Court take this case up for review, since it presents an interesting and important issue for potential litigants who are trying to resolve a dispute as a limitations period approaches. You need to know whether you should be using the word waiver or the word tolling, and what the difference is, if any, between those two words. And that's it for today's Kelso Report. Have a great day in the law.